If you used AI to help prepare a submission tonight, and tomorrow a judge asked, "Counsel, have you actually read the authority you're relying on?" Would you be completely comfortable saying yes? Because the AI risk for advocates is not just fake cases. It's something more uncomfortable. AI can produce work that looks exactly like competent legal work, while quietly undermining your judgment, your credibility, and your professional duties. And that matters, because in court, sounding plausible is not the same as being right. Used well, AI can save time, sharpen drafts, and help with first-pass research. Used badly, it can put you in front of a judge defending a point you didn't properly check, didn't fully understand, or should never have made. For barristers, solicitor advocates, trainees, supervisors, the issue is simple. AI doesn't carry your duties. Your duty to the court, client, and to exercise independent professional judgment is your responsibility and your responsibility only. So yes, let's take a look at some of the red flags quickly and then get to the ones people miss. If you're pasting client facts into a public or free AI tool without approval, controls, or understanding where that data goes, that's a problem. We've already seen lawyers, including in real court settings, criticized for citing cases that simply did not exist. If AI gives you an answer and you treat it as a shortcut to certainty, that's where trouble starts. But those are the headlines. The deeper risks are more subtle, more dangerous, and more likely to catch competent lawyers out. AI often sounds more confident than a junior tenant, a difficult opponent, and a partner on 4 coffees combined. That's the trap. A bad argument written badly is easy to spot. A bad argument written smoothly, logically, and in perfect professional English. Much harder. You read it and think, that sounds about right. Then you stop interrogating and let it pass straight through. For advocates, that is dangerous. Because your job is not to repeat polished words. Your job is to test them. A subtly wrong summary of a real case can survive long enough to make it into your note, your advice, or your skeleton. Imagine asking AI, summarize the key principle from this Court of Appeal case. It gives you a neat paragraph. Concise, balanced, entirely usable. Except it has quietly flattened an important distinction, missed the procedural posture, or compressed away the very factual wrinkle your case turns on. And if you rely on that summary without checking the judgment yourself, you're not using AI as a tool, you're outsourcing legal analysis. AI struggles with legal nuance and procedural context. Law is rarely just what's the rule. It's what forum are we in? What stage are we at? What standard applies here? What would irritate this judge? AI can give a technically tidy answer that is totally misaligned with the real procedural posture of the case. It is often better at answering, "What is the law?" than, "What matters here today in this courtroom?" And in advocacy, context is vital. Context is the case. Outdated law presented as if it's current. AI may give you a convincing answer based on old procedural rules. No dramatic error message. Just stale law in a fresh-looking paragraph. And because it reads so cleanly, people are less likely to ask, "When was this actually true?" AI can help produce a polished skeleton, a witness summary, or a client email. But if it generates an argument faster than you can properly analyze it, you may end up signing off on reasoning you couldn't confidently defend under pressure. If a judge pushes back, or your opponent exposes the weakness, a useful question is, could I stand up and explain every sentence in this document without the screen in front of me? Could I take the court to the paragraph that actually supports it? If not, it isn't ready. None of this means don't use AI. Use it like a sharp tool, not a substitute mind. So, let's take a look at the key messages. Never cite what you haven't checked yourself. Use AI for first drafts, not final judgment. Check date, jurisdiction, and procedural posture every time. Don't put into AI what you wouldn't be comfortable explaining to your client, supervisor, regulator, or judge. If AI gives you a point you couldn't defend aloud or locate in the underlying authority, don't use it. The lawyers who use AI well won't be the ones who trust it most. They'll be the ones who know exactly where not to trust it. And that's the skill to build now, before a court, a client, or a regulator builds it for you.